we are gathered here this afternoon to share with the members of the press the developments as far as the ordinance on the integrity issue is concerned. A bit of a background story, just to repeat what was said before in different settings. The matter of the integrity reports we've had last year, there were 3 integrity reports prepared. One by the PricewaterhouseCoopers, that on the request of the Dutch government through the governor. The other integrity report was done by the Commission Bob Witt, and that was done on with local people involved. That was done on the request of the government at that time, and we also had the one made by the General Audit Chamber office. As a result, in the former government, work was prepared on preparing for the executing the matters of the recommendations, rather, in the integrity reports. And as time changed over and this government sat, we also continued that process. In fact, to be more exact, the first governing accord of this government stated clearly that one of the action points, one of the points in the action plan was to give priority to arriving at a decision regarding the various reports on the integrity of the public administration and subsequently the execution thereof. So in the government accord, this was a point pretty high up on the action plan. It was one of the points to be given priority, and in this cabinet we did give it the necessary priority. What we did encounter also as a new cabinet, where we feel on the insistence of the second members in the second chamber, the Dutch Kingdom Council of Ministers, they continuously try to get the integrity chamber established according to their norms and their conditions. First of all, using the Article 38 of the Charter, the Statute of the Kingdom, where in that Article 38, as we've explained before, there is a part where that could be done via consensus, which means in agreement with us, and we rejected that approach and continued preparing our own integrity ordinance. It was a long, bumpy road, and where we continuously were asked to come along with the Dutch in form of a consensus, which means an agreement with their approach, and we insisted that we are going to do it according to our laws, according to our constitution, and we got so far now that our ordinance was presented to Parliament a couple of weeks back, and we had a first reading of that law in the Central Committee of the Parliament sometime back last week, Friday. This week, Monday, we continued in Parliament with the members of Parliament on the handling of this law in the Central Committee. The comments and remarks is by the members of Parliament is known to us all, was very well reported by you, members of the press. And now we have reached a stage where on Sunday, the Minister of Justice will be traveling to the Netherlands. And the reason he's traveling to the Netherlands is, in the meantime, the Kingdom government has got away from their efforts in using Article 38 to bring a kingdom measure of rule according to the Algemene Maatregelen van Rijksbestuur, a general measure of kingdom rule against St. Martin using Article 38. In that article, as I've said before, they would have needed our assistance in having a consensus and agreement on that. So they've chosen now to use another article in the Charter, which is Article 51. And in using that Article 51, they have, according to law, they have forwarded the draft kingdom measures to the Council of State, and the Council of State, according to law, have to hear the country involved, in this case, St. Martin, our comments and our remarks on that kingdom measure. And that is why the Deputy Prime Minister, Mr. Dennis Richardson, will be traveling to the Netherlands on Sunday. The meeting will be on Monday afternoon, where together with the Minister of Interior Affairs, Mr. Plasterk, on Monday afternoon at 5, the Dutch time, Holland time, there will be a hearing to basically hear St. Martin's position on the request of the Kingdom measure of rule using Article 51 of the Charter. I think that's for now the introduction of the state of affairs where the Kingdom, where the integrity ordinance is concerned, the whole integrity matter, and I would like to give the floor to the Deputy Prime Minister, Mr. Dennis Richardson.
The debate on the national ordinance, as you have naturally reported on, is continuing with the members of Parliament of St. Martin. In our opinion, it is quite understandable that our members of Parliament who have the right also make use of that right to question the law in depth. And the reason for that is also the fact that nowhere in the kingdom there is such an integrity chamber, and therefore there is no experience, has been no experience built up with such a new development. And therefore, if there are any doubts, any question marks in this regard, it is naturally the right of the members of Parliament to question such a development in depth, on its consequences as well for persons who might be subjected to integrity investigations, and to ensure that we have a law that is proper and functioning. We have been able until now, we believe, to give adequate answers to questions and doubts that have been posed during the handling in and outside of Parliament, because naturally the conversations continue all the time. And we believe that in the end, we will be able to convince our Parliament that this is a good thing, that not only the PwC report, but also our own Integrity Committee has established that one of the main issues, and that is something that is in all three reports, the General Audit Chamber, our own report from the committee with Samson, and from the PwC report, one of our main weaknesses is compliance. And if there is no compliance, or if a civil servant or a minister or whoever deviates from rules and regulations that have been in place in an improper fashion, there are no consequences. And the Integrity Chamber is intended to do two things. One, on the one hand, to establish where there is lack of policies, lack of regulations, lack of checks and balances from a point of integrity in government, but also to investigate whether integrity breaches are taking place, and what measures can be taken to correct that. There is some confusion as to the role of the Integrity Chamber. It is continually being confused with criminal investigations. Criminal investigations is the sole authority in that regard is the public prosecutor system. The aim of the integrity investigations is not so much to seek criminal offenses, because in that case, really, they have to abide by the rules of the criminal law and the whole system that takes place. We are talking about administrative law. We are talking about permits, for instance, that might not have been issued, or permits that should have been issued, or permits that have been issued in conflict to policies that are there. And then it is the idea that that the Integrity Committee makes recommendations to the Council of Ministers on how to correct the situation, how to correct the situation. It is also not so that it is the Integrity Committee that decides in the end. That is also a very crucial point that we tend to forget. The committee comes with an advice to government. In the law, it said it's binding. And why is it said it's binding? Because if we do not react to the advice within a certain period of time, then the advice comes into effect. Then at that moment it becomes binding. But if we do, if we have justifiable reasons, for instance, to deviate from that advice, that decision is taken and the decision of the Council of Ministers stands. There's a little bit of confusion there. Maybe we have not explained that sufficiently and properly and in depth yet. But that is the case. The only aspect of criminal law that plays with integrity chamber, that if they investigate integrity breaches, come to the conclusion that in this case there might have been a criminal offense, then they have to turn that investigation over to the public prosecutor, and the persons involved enjoy all the benefits and protections of the right of criminal courts and criminal procedures, and they do not lose that. But even in our system, where it concerns administrative law, we have offered the persons who might be subjected to integrity investigations protection in the form of making the diverse handlings of the integrity chamber can be subjected to appeal on the administrative judge, and he can judge whether or not what is happening is in contravention, for instance, to the rights of these people, is unnecessary, or is assumptions and not facts. Those kind of things it can be subjected to, and that gives our people who might be subjected to these kind of investigations. And as you know, in a small community as ours, as I've stated before, once you're being investigated, you're considered guilty until proven innocent, and that can affect the proper functioning of the persons in our community. So we therefore have no other option than to give them the protection that they need in this regard, so that they cannot be unnecessarily harassed or unwarrantedly subjected to investigation with all the negative connotations that may be involved in that case. What is not realized to a great degree, I believe, is because we are so focused in debating our own national decree on integrity chamber, is that some have lost sight of the General Kingdom measure and how that is put together and how that integrity chamber is supposed to perform. And in fact, the General Kingdom measure gives the integrity chamber free rein and no protection for persons subjected to the investigation, other than in the case of a criminal event, they can, as we call it, verschoningsrecht, they can refuse to react to the chamber. But that is the only aspect of it that gives protection. The problem is there are so many handlings preceding such a conclusion that could already have compromised, justifiably or unjustifiably compromised the position of persons subjected to those integrities, that it really doesn't offer sufficient protection to the persons who might be subjected. I expect, honestly, that the Kingdom Council of State can only be very negative on the law itself, because even though it's the Kingdom Council of State and they have a lot of discretion in establishing a General Kingdom measure, the kingdom itself, the whole kingdom, is subjected to the protection of human rights, to the Treaty on Human Rights, the European Treaty on Human Rights, the United Nations Treaty on Human Rights. So even if there's not a specific law in the case in which the Kingdom Council of Ministers is operating, they have to abide by those laws. In my opinion, by ignoring those aspects in their measure, their law cannot, in my opinion, be upheld. And I expect that the Kingdom Council of State, based on my experience there, will have something very hefty to say about the quality of that law itself.
We have, besides the integrity chamber issue, there's also another issue that is playing a very strong point in this whole relationship issues with the Dutch, and it has to do with the agreements of cooperation where the justice system is concerned, and that has been been taken totally out of proportion, in our opinion, where as a kind of balance, the Dutch have put it on the, I would say, on the tail of the integrity issue, and has been putting the necessary pressure and demanding certain, I would say, coming with some demands where it concerns the matter of maintenance of justice on St. Martin. And I'm sure the Minister of Justice will elaborate a little more on that.
Indeed, in our efforts to try and prevent a major confrontation and constitutional crisis with the Dutch government, we, at their request, not at our proposal, at their request, agreed we will also make agreements in the protocol, not only to concerning their role in the integrity chamber, but at their request and insistence, they wanted us also to make agreements on how the help that they have offered in strengthening the justice chain in Aruba, Curacao, and St. Martin would be applied in St. Martin. We have no problem with that as long as that happens in accordance with what we agreed to in the justice consultations of the 4 ministers. And in that consultation, it was agreed that the assistance that would be rendered to Aruba, Curacao, and St. Martin will take place based on proposals coming from the justice ministers and within the present legal division of authorities within the countries. To our major surprise, proposals are made that are completely in conflict with that. As far as St. Martin is concerned, they seem hell-bent on creating at least 2 new law enforcement agencies completely independent of the Minister of Justice. That is the only conclusion I can draw from the proposal that they have put on the table, which is like cussing in the church of constitutional law. This is not acceptable. Nobody knows who's responsible then when something goes wrong. There can be no directions then from the person who's responsible for their activities towards Parliament, which is the Minister of Justice. And I'm not talking about me personally. I'm talking in general. That is the structure within our kingdom. And worse is that there are no reasons given why that should take place. They are not saying, well, the police force is incapable, or the police force is corrupt, or the immigration, they're not saying anything, they're just saying, this is what we want, and this is what you have to accept, and if you don't accept, then we don't have an agreement, and if we don't have an agreement, we're therefore going to pursue the implementation of the integrity chamber by general kingdom measure. What the two have to do with each other is completely lost on me, because simply, like I said, the integrity chamber has to do with administrative law. The help offered to the justice chain has to do with criminal law. And what the two have to do with each other is as unclear to me. Why the two should be tagged in principle is unclear to me. But if you're going to do it, you have to do it within the realms of the present laws that we have in place. And you cannot, in the course of a onderlinge regeling, as it is called, an agreement between 2 countries, deviate from the Rijkswet-politie, from the Rijkswet, the kingdom law on police, the kingdom law on public prosecutor system. It is a completely riddle to all our lawyers how they can come with such proposals and then expect a self-respecting country within this kingdom who wants to abide by all the laws and constitutional laws, or who have been accused of not abiding by laws and therefore create integrity breach, suddenly want us, in their proposals, to create a new integrity breach by agreeing to things that are in conflict with the kingdom laws. I mean, you got to be a joker of some sort, or they maybe had a mental crash when they were developing the law or something, but it seems to me completely loco, to use a good English word.
Thank you very
Thank
much,
you.
Minister of Justice, and of course, PM, for the opening remarks. I open the floor for any questions that the media might have. Ms. Shaw, I'll give the microphone to you.
Good afternoon, Cedric. Good afternoon, Mr. Prime Minister, Minister of Justice. In your opening statement, Minister Richardson, you said that you believe that the Council of Ministers will be able to convince Parliament, based on what we have heard last week when Parliament was debating in this Central Committee. It is clear that there is a big division. The Parliament, like you said, doesn't seem to understand. But tell me, why do you believe you still can convince Parliament, especially the majority, to go with this law?
Well, as I've stated, I said it is the right of Parliament, and given the newness of this thing, and it has not been tested in practice within our system, I can understand the doubts. I can understand that the members of Parliament also get legal advice, and that questions are posed. And if we are not capable as Council of Ministers to answer that, then yeah, they have a right to even amend the law as far as we are concerned. So that is not a point. But we believe that in the end, after debating the issues, after the debate in the points for point, and as you've noticed at the last Central Committee meeting, after I went through all the observations that they have made, you could say, well, maybe they were not completely convinced at that point, but you could see that a number of their concerns were taken away. And I believe as we go along with that, I believe we have a good, properly prepared law, very well thought through by our legal minds here at the government, but also third parties helping us, looking over our shoulders, that we have a solid piece of legislation. Can it be improved? Probably. Might there be things in it that might need sharpening up? Well, we will see in the process. Like I said, the constitutional process of establishing the law is continuing, and the members of Parliament are playing the role that they should play for the first time, not for the first time, but very solidly at this moment. That is their role. They're doing it very well. Their questions are critical. Their questions are sharp, and we have to deal with that as Council of Ministers. But I believe in the end that we have convincing arguments to continue and to convince them that it is a good thing that what we are doing. Content-wise, given the reports that we have, the nature of the integrity chamber, like I said, to administrative law and administrative handling of government, and focus on compliance. It's not focus on punishment. It is the focus on compliance. And that, I think, is a good reason, content-wise, why they should pursue the establishing of this law.
I've heard you said it last week, and I'm hearing you saying it again, that this is St. Martin's draft law to establish the Integrity Chamber. But if I understand correctly, the Kingdom has 2/3 majority and the Secretariat. How much control would St. Martin have on this? And then I'll go right into my third question so you can answer at the same time. Why did we choose to draft a law to establish the Integrity Chamber when you rightly mentioned the rights with police? Article 9 says the Attorney General has a detective at his disposal to do any type of integrity investigation. Why didn't we choose to then develop or build this department, or create a department so that this department can conduct integrity investigation and not a separate integrity chamber?
The law that we put forward for establishment has a number of compromises in it, and as I've said, we were trying to prevent that we will get into a major constitutional conflict with the Kingdom government, and to accommodate some of their wishes. Naturally, we've made concessions, because if you want to stop somebody from doing something that they have the authority to do in first instance, and you can do that by coming to some kind of agreement and prevent a frontal confrontation, then we felt that that was a justified route to go. And one of the requests that they made was to play a role in the establishing of the Integrity Chamber. And their proposal came down to it that they would practically, completely alone establish who would be in the Integrity Chamber. And naturally, we objected to that. And in fact, in our proposal, our first proposal, in which the President of the Joint Court of Justice, the Vice Chair of the Council of Advice, and the president of the Constitutional Court were the persons who would propose who is to be appointed to the Integrity Chamber. That is, in our opinion, completely void of any political influence, and gives the Integrity Chamber a more objective functioning position. But because they insisted that at least it was for the appointment of the Supervisory Committee of the Integrity Chamber. But their insistence was get rid of the Supervisory Committee, and we want to play a role in the appointment of the members of the Integrity Chamber. Well, unless I was sleeping when it happened, an appointment by the Council of Ministers of the Netherlands is, in my opinion, a political appointment. Unless they don't have any politics in the Netherlands, which I don't think none of us here believe, right? So if you want to use your politics within my Integrity Chamber, then I need to counterbalance that with appointing my own person in the Integrity Chamber. So the compromise was clear. If you want to appoint one, I will appoint one. Okay, but how are you going to appoint the third person now in a way that not one of the two parties has the sway in that whole story, politically speaking? Well, the compromise was those two persons that we appoint will get together and seek a chairman who is going to be objective chairman of the group. He's not appointed by St. Maarten. At least the proposal is not from St. Maarten. The proposal is not from the Netherlands. The proposal is from those two persons who are in the Integrity Chamber, and therefore you can get a more objective person in the chair of that group. So it's not a two-thirds. It is shared in that sense. Now, in the General Kingdom measure, all members of the Integrity Chamber are appointed by the Dutch. That's what it boils down to. Not only that, the Secretariat is made available, civil servants made available to the Integrity Chamber by the Dutch government. Now, in my opinion, that's completely political. Yeah. So they're conflicting themselves. On the one hand, it's not supposed to be political, but clearly, if it's political on the Dutch side, that's good. That's independent. Now, I don't know where they get that notion from, because when I'm listening to the Parliament of the Netherlands, and I hear Van Raak speak, and I hear Bosman speak, all they're doing is bashing St. Maarten on a continuous basis, and none of those bashments or perceptions or whatever they have are based on any facts. They've not produced any facts to date. You yourselves in the newspaper have reported to that. All of these statements are made, there's no facts. So if that is not political, what is? So, so what we're going to get if the Kingdom measure goes through is a completely political organization run by the Dutch without any limits to do whatever it feels. Maybe that they were not able to bring in their Secret Service people with the screening of St. Maarten. Maybe they'll put them in now, because you know what? In that proposal, the Integrity Chamber can now screen all civil servants. Screen all civil servants and can screen ministers. So now, because our good governor was strong enough to tell them that they were wrong with what they were proposing to do in conflict with our laws, they have found another route to try and still impose whatever it is that they want on St. Maarten. So they can fill it up with Secret Service agencies, and then instead of going off integrity breaches, they'll probably try to go after criminal investigation. And then we will mix in the two, because now suddenly we have an Integrity Chamber, politically run, out witch hunting, trying to see if some minister or some civil servant has done something criminally wrong, while that is the task of the public prosecutor system.